everyone, and welcome to the next installment of our series of webinars around global workforces and mergers and acquisitions. The focus of this webinar today is all around GP processes and employment pre-transfer mechanism. But before we get started, a bit of housekeeping. You can ask questions throughout the webinar. Just use the chat on the right where you show to your Q&A section. Just clicking there. You can answer. You can ask questions. You can ask the questions. We'll answer the question towards the end. We'll leave a picture of that. Now, before we get started, let me start by asking my esteemed panelists to introduce themselves. James, why don't you go first?
Thanks, George. Hello, everyone. My name is James Mallet. I'm co-general counsel and the corporate compliance team here at Omnipresent. Been with Omnipresent 2 years and based out of our Lisbon office. My background was in banking, finance, and asset management. I've led some legal functions with a number of international groups, listed and regulated, and worked on some M&A from both the advisory and client side. I'm supported by an excellent employment law team here at Omnipresent for such matters with today.
Fantastic. Emma, over to you.
Thank you, George, and thank you, Jane. I've got over 20 years experience in pensions and benefits broking and consulting at some of the larger global consultancies like Mercer, KPMG and Willis Towers Watson, and some smaller boutique firms as well, providing more niche services. I've been involved in a number of benefit merger and harmonisation projects, and I'm currently heading up all things global benefits at Omnipresent, supported by a fantastic team who've got merger and acquisition experience from both the client advisory and in-house implementation angle.
Amazing. Welcome, Emma. Welcome, James. Glad to have you both with me today. So let's get things kicked off. Why are we talking about cross-border mergers and acquisitions and transfer mechanisms in TP? For you to mention, just to begin with, that when businesses go through significant changes like a merger acquisition, they may end up in situations where they need to change the employment of their team members. Maybe they are inherited a new legal entity in a country and need to transfer employees from one entity to another, for example. And this can be a very complicated activity. It can be fraught with risk and incredibly important to get it right if you really care about employee retention. So that's why we're talking about this topic today. It's something that comes up fairly frequently in our interactions with our client. So what we're going to be talking about today are a few different topics. So firstly, the different employee transfer mechanisms and how they might vary by country and by local regulation. We'll dive a bit deeper into one of the most common considerations when transferring employees and like laws like 2P. And then we'll look at specifically how TP might be triggered, the process, the key theme. Hopefully everyone on the webinar will walk away a little bit wiser with a few nuggets of insight from today. So let me frame this a little bit. I was reading a recent report by PitchBook that found that merger and acquisition deals in EMEA and the US would generally becoming more and more cross-border. And that's a trend that's been going on for the last 7 years or so. In EMEA last year, the size of the total cross-border merger and acquisition deals was $856 billion. This is a huge market, and it seems to be on the increase. Now we're seeing that driven by a lot of rising industries like AI, electric vehicles, and clean tech. They're kind of stimulating a lot of this growth, which I think is a really interesting kind of trend going on there. And what happens when you have these cross-border M&A deals? They come with increased complexity around employee transfer mechanisms. Right? So, Emma, let me come to you first. Regardless of the mechanism that you use, what are the key things that everybody should be thinking about when you have to go through one of these transfers?
Thanks, George. I mean, whether a company is going through a merger and acquisition, a divestiture, or a carve-out, there's 3 key points that need to be considered. The first one is aligning the contract. This includes managing the leave entitlement. So a leave entitlement's transferring between the employers. What about the seniority? Then there's the benefits alignment, of course, that covers healthcare, pensions, allowances. This is super important because not only might specific rules apply, depending on the country, the benefit, or even down to the employer's type of business, but also because benefits can be really emotive to employees. And then the third one is the human touch and the communication with the people. The considerations are going to differ slightly depending on which employee transfer mechanism that we're going to be talking about.
Yeah, that makes total sense, especially the human touch. This can be a really kind of turbulent period for an employee who's working at distance has gone through one of these transactions. So yeah, really, really traumatizing that point. So these are some of the considerations. James, over to you. Why don't you give us a bit of a summary of the different employee transfer mechanisms that might apply in different countries?
Sure, Doc. So broadly speaking, you'll have three types: termination and rehire, resign and rehire. For both scenarios, the former employer would pay all statutory severance payments in full, all accrued benefits, etc., holidays. And afterwards, the new employer would hire the employee, starting a brand new employment relationship. The other category is employer substitution, employer transfer. This method allows for the employee to be notified of the transfer of their employment to the new employer without the working conditions to which they're subject being altered. The continuity of employment is often. And this is where we come from TUPE. So anyone who on the call not familiar with it stands for the Transfer Undertakings Protection of Employment Regulations, which is a bit of a mouthful, so we'll go into that. This came into effect in 2006. There's also many other EU equivalents to be implemented by member states following the Acquired Rights Directive, or ARB, and then equivalents in other countries outside the EU in case-by-case basis, which each may provide a structure for such transfers.
Yeah, that makes sense. So let's dig into that, the two-piece structure in a bit more detail. Obviously, if you're navigating a merger and acquisition, and you're dealing with UK employees, UK being still one of the most common hiring markets, especially in Europe. Let's dig a bit deeper. What else do people need to know about this process?
Well, thanks, George. Probably seen as an opportune moment to note that we're not legal, tax, or benefits pensions advisors, especially as I can see maybe one of our partners on the call that do provide such a service. So please do not take this as advice. Not that I hope anyone would make that assumption. So yeah, TUPE regulations are to ensure that employers follow said steps in connection with a relevant business transfer. Again, the objective is to protect the entitlement of employees to the same terms and conditions with continuity of employment as they had before the transfer, and it is known as the automatic transfer principle. And TUPE provides a process by which the information about the transfer and any proposed changes to the employment relationship are provided to the employees. Consultation then can occur between the employee and the new employer. With the employment relationship, contract terms with any leave, maternity, potential rights, accruals, etc., transferring across as part of the transfer. So unless there's any redundancies, obviously, or changes to terms that may occur within very specific parameters under the process.
Got it. So it's all about making sure that transfer goes as smoothly as possible. Right. So in what instance would TUPE typically be, as a mouthful for you? In what instance would TUPE typically be triggered?
That's a tricky iteration. Sure. The high level applies where you've got employees based in the UK, and there is a relevant transfer, regardless of domicile of the acquirer company. Broadly, within that two scenarios where this occurs, we've got business transfers. So where there's, again, technical term of transfer and economic entity that retains its identity. But where the business unit is essentially transferred from one employer to another. So the acquirer, and this could also include a share sale, not just the transfer of like a sales team, for example, but including the entire equity transfer in a company. If that involves the acquirer taking control over the company's business and involves in restructuring or reorganization as part of that process. And then the second type is a service provision change, and this might happen where a company either outsources a service, but it internally for the first time moves it between service providers, or enforces it back again. There are many employment tribunal cases defining the parameters of these and what gets caught hugely complicated. And again, your legal advisors are the best people to advise you on whether you're in or out, or TUPE on potential acquisition.
Makes a lot of sense. I heard that loud and clear. Emma, so you've obviously been quite hands-on with a lot of these kind of processes. I think you also were very heavily involved in us, like making sure that we had our plans and audit here and creating our playbooks for this. What kind of things should people be thinking about in terms of a TUPE checklist when they're going through these processes?
Well, there's actions that are before the transfer, and then there's actions that are during the transfer. Before the transfer, it's really crucial to grasp the legal intricacies of TUPE or the relevant regulation, and how they impact the transferor and the transferee. Expert help, we've not mentioned it before, but it's really, really important. Legal advice relating to rules that are local, regulations, I mean, that's a given. Particularly important in countries where there's collective bargaining agreement. But it's also important to consider benefits advisors who are experienced in employee transfers and the requirements that specifically relate to benefits in that local country. And the value of a good benefits broker, cannot be underestimated, one who understands benefits and harmonization. When we typically work with companies in conjunction with our clients and in conjunction with their advisors and our advisors, all the employees are identified who are affected. That's whether they're moving to the new employer or whether they're staying with the old employer. And that covers full-time, part-time, and temporary staff. Ensure that you've got to conduct a thorough consultation with the employee to discuss the transfers, implications, the employment rights and benefits, and ensuring that all of the procedures are perfectly followed. In the UK, particularly, there is a change that's coming in on the 1st of July. This is for when transfers are taking place or not after the 1st of July. The employers can consult directly with the employee instead of previously having to elect to consult with the employee representative. If the employer is a small business with less than 50 employees, or if it's a transfer with only less than 10 employees, then transferring in duty. So this section previously only applied when there was less than 10 employees. So this change in regulations makes it much more easier and practical for our businesses. Then next, the contracts and policies for the workplace be reviewed within the transfer of the same employment, including the wages and the working hours. And then in terms of process, it's important to clarify how the existing benefits like pensions and healthcare are going to be handled. Are they going to continue as they are? Are they going to change under the new employer? So this is all going to be included in a document called the Employee Liability Information Sheet, and that's a mouthful as well. And that's one that the old employer has got to provide to the new employer more than 28 days before the transfer. The new employer has then got to send the old employer what's called a measures letter. And this has got indications of the proposed changes, the employer arrangement that they want to make. And it's for the old employer to consult from the employee with these changes. Specifically for 2P, the old employer consults the employee representatives by sending them to the transfer letter. There's no specified minimum consultation period for the transfer. For a transfer alone, employers have got to provide the required information to the employee representatives long enough before the relevant transfer to enable consultation. However, if there's pension particularly, or the benefits, there may be specific consultation requirements that apply to those, and that's really relevant in the UK. It's really, really important to get the consultation piece right, because if an employer fails to get it right, then they can face penalties, including having to pay staff up to 13 weeks pay in compensation, and that's the transferor and the transferee are both liable to pay this. So on average, it's about a minimum consultation period of 3 weeks, which is deemed reasonable. There's a comprehensive transfer agreement that's then got to be drafted to outline all the terms clearly, ensuring compliance to GP, and communication is absolutely key. A well thought out plan that's going to keep everybody informed and supported throughout the process will reduce the anxiety and smooth the integration into the new organisation. And then finally, before the transfer starts, it's really vital to ensure that the HR and payroll systems are prepared for a seamless transition. We've got to get strict compliance maintained at all times with all of the employment regulations. So that's everything that you've got to do before the transfer. And then during the transfer, you're going to have to provide specific details of employee entitlements and personal details. So for 2P in the UK, this typically includes terms and conditions of employment, the date of continuous employment, age, any previous disciplinaries, grievance, issues or claims, collective agreements, whether they've been previously made or if new ones apply, as a result of the transfer, pay details, how and when they're paid, deductions from wages to things like child support, student tuition, etc. All payments, including overtime, commission, bonus payment, holiday entitlement, company sick pay, benefits such as private health, and of course, pension rights as well. And that's just the list for the UK. For other transfer mechanisms and for other countries, there may be other requirements. So again, it's always vital to refer to legal expertise.
Yeah, that sounds really simple, Emma. After a few words, James is both pointing people towards legal advice on these things, right? I think that's a really, really good signpost. But let me go back to something you mentioned at the start. You talked about the human touch element of this, and I'm curious to get your take, having been involved in a lot of these. Like, what about after the transfer? What kind of things do you think back here, and how can you ensure that employees feel well connected and well integrated after the transaction?
I mean, of course, maintaining those relationships during the employee transfer is absolutely crucial for morale and a really successful integration overall. So I'm going to proactively manage the staff morale. It's going to be really necessary, especially if there's going to be any potential dismissals or changes to terms. Organisational restructuring may be needed to integrate the new services and the employees, but changes are all subject to the terms of the 2 key limitations. The key here, as I said before, to help you reduce that negative risk on morale, is a really quality communication plan. And that includes timely employee information, providing opportunities for questions and answers in advance, and feedback sessions after the transfer.
Yeah, that makes a lot of sense. So, James, let me come back to you. When you think about this in the context of mergers and acquisitions and some of the complexities that are being dealt with by company users during this period, what are some of the legal considerations that you want to give?
Thanks, George. Yeah, definitely a few things at play. Again, it's maybe reiterate the point. Time and resource is key for this. You really can't start the process early enough. Proper analysis and planning. Also, under the transaction due diligence itself, you might identify issues that need remediation. This is where we see clients need support on remediating contractors who've maybe been misclassified, or might need to support remote workers where, post-deal, there might not be a legal entity in that country for someone who's moving as part of the transfer. So you really can't start early enough, because there's always some things that pop up which were unexpected. And again, your legal tax advisors will do the analysis with you at the early stages, and also service providers should be in panel for those edge cases or for those issues.
Got you. And what are the key risks that people should be thinking about? I guess not just for the acquirer, but also for the target company being acquired as well.
Yeah, there's obviously quite a few. So as Emma's already mentioned, there's just the penalties under the process itself, which can be quite punitive, especially if it's a large group. So you've got your kind of material, legal, and financial risks under the process itself. And it's very complicated, but there's obviously your unfair dismissal claim. So subject to the 2-year qualifying hurdle, if there are any redundancies on the transfer, these might be automatically deemed unfair unless for an economic, technical, organizational ETO reason. So basically a change in the number of employees or structure you need to perform that business function, so a legitimate business need. But even then, under an ETO, redundancy is still subject to the rules of fair dismissal, and the process needs to be followed. Also similar with changes to employment terms, due to an ETO, this needs to be made. And even with, you'll still need employee consent, or these might be void or grounds for unfair dismissal. You've got the transfer of liabilities, of course, that move across as part of these transfers. So unpaid wages, historical discrimination claims, any, grounds for unfair dismissal that already exist in past to the new employer. But of course, the new employer under the deal may seek warranties or indemnities from the outgoing employer. So really under everyone's interest to get those right remediated pre or during the deal. Then probably some more esoteric things like non-financial legal risks that pop up from time to time. Is the operational risk on integration of these new employees into HRIS, finance systems, etc. And again, the wider issues around company culture and employee morale.
Yeah, that's a really that's really good points there. And how does this, in your mind, compare when you're dealing with like a mix of countries? Somewhere there may be 2P laws in place, others where there may not be. How do you come stitch all this stuff together?
Well, yeah, if I was advising a company on one of these multi-jurisdictional M&A deals outside the UK or involved in the UK, look at other countries and see have their equivalent employer substitution legislation there. Often these are a bit more flexible for consultation periods and formalities than 2P or ARD derived laws, but still seek to respect the principle of stability, continuity of employment, work conditions, etc. So you've got a deal involving many countries. You're going to have to look at the kind of whole board, so to speak. and think about countries that you face 2P obligations or kin to 2P obligations, or those that are kind of unregulated in this area. But even then, you might decide as part of that analysis, which is why it's so important to start early, that you want to align your contracts and benefits across these multiple jurisdictions, have a certain bar for standardization policy or employee value proposition. So you might take a kind of a blended approach from a human resources perspective as well as a legal one, minimum requirement.
Yeah, that's a really interesting point. So we're going to take all of those legal foundations, put them into that discipline that people understand and like make it really easy for them in the form of a comms plan. Maybe Emma, I can quickly on that. How do you kind of balance the social emotional side of it with all of the legal considerations? How do you think about like an empathetic comms plan for employees who are going through that kind of transfer?
I mean, I'd say that there's really 3 pillars to this: transparent communication, empathy and understanding, and then lots and lots of internal training and support. For instance, are there elements of the legal aspects of the transition that are worth communicating in a company all hands or a team meeting to give the people a chance to field the questions? How are you going to build a cadence of constant communication as things evolve and change? And how can you empower department heads and line managers to act as the spokespeople for their team? And you've got to reassure the affected employees that you're listening to their concerns and give them the chance to put their views forward.
Yeah, that makes total sense. Great. I think we've covered a lot of ground here in a relatively short bit of time, so I think there'll be hopefully some good nugget to take away from this. I want to come to, there's one question we've got in the chat, and James, I can put you on the spot a little bit, but we're not giving any legal advice, but in that caveat in here. So there's one that's come in from Aya. She says, to clarify James's last point, under 2P, when you were talking about asset purchases, under 2P liabilities transferred to the buyer even in an asset deal.
Yeah, sorry if I misspoke. That was definitely my intention. Yeah, these will transfer. Again, you need to know where you are on those definitions, but yes, they're often caught, and there's some interesting case law on that. So yeah, completely agreed.
Perfect. Well, look, let's summarize a bit here. So it sounds like I'll give you some of my key takeaways from this. There are different ways of transferring employees in different countries, and different countries will have their own local regulations. As Emma mentioned, there are still foundational pieces that you'll need to get right regardless of the country. There might be countries like the UK where there are specific regulations in place. My key takeaways from this are big people that know about it. That might be likely legal advisors, but also if you're looking to make this transition to your EOR company, make sure that the EOR company has the place. Frankly, I don't need to know all of this stuff because I have Emma and James within my teams, and they're thinking, well, who can real key considerations. So lean on the expertise. And the last thing I think is that empathy communication approach, because there's a load of complexity behind the scenes. There's all sorts of different forms of penalties and ways to get caught out. But at the end of the day, we're dealing with people, we're dealing with humans, we're making sure we have that empathetic, really clear, really transparent communicate plan, and make sure we're really thinking about all the different boxes and making sure we tick them all. Things are really crucial elements of this, because it's going to be a period for employees which is fraught with risk, uncertainty, and all sorts of things in between. So those would be some of my key takeaways. But James, let me hear from you. What are your key takeaways on this?
So without, obviously everything's different, every deal is different. So really, really high level things. I think I mentioned start early. So handling your tax legal advice is a good time, ideally from the planning stage. Bring in service providers also, allow the sufficient time for analysis, decision making, and communication. It really cannot hurt. Obviously, you understand the legal and regulatory requirement across all the jurisdictions you're involved with, and obviously understand your obligations to the effective employees. With that comes the due diligence, which we spoke on before. So obviously, you're reviewing the contracts, collective agreements, pension schemes, as we've mentioned many times. Some of the things you might find there, your contract misclassification, payroll or otherwise, you might want to do before the DD, but others can be remediated as conditions precedent under the deal. So those probably, just start early with the advisors. So if there are any things that are unexpected, you have enough time to build those in and you don't delay your deal execution. Like we had a recent case where we were working with the acquirer pre-deal. We were able to do a lot of the work pre-deal. So when it came to time to sign and complete, we were already start working with the USD part of the acquired group, which we couldn't work with due to confidentiality before then. So sometimes you might need to start early with your service providers as well, and that really cannot hurt.
Yeah, that makes a lot of sense. I certainly echo that. When we can get into the situation and understand the setup as early as possible, really, in the deal, then we can definitely set clients up for success. And Emma, what are your key takeaways from this?
The more top tips than key takeaways, and you've already covered 2 of them, so I'm really glad that you've managed to take those away from this conversation. But the ones you've covered, make sure the right people are in the conversation. Seek professional advice, as we've already said, particularly when dealing with pension arrangements. But from within the 2 companies, it's really important to have the right people within the companies in the conversation. So the HR leaders, the legal advisors, finance experts, and then if required, those employee representatives as well. Because it's not only about bringing the right people in, it's making sure that they're brought in as early as possible in the process, as James has already said. And that is in order to gain the insights, address the concerns, and build the consensus around the benefit decision. The other one that you'd mentioned was the communication. So I'm going to tie this in with the consultation as well. So depending on the jurisdiction, there's got maybe legal requirement to have consultation with the affected employees. It's really important that you've got to absolutely follow the compliance rules on this consultation. Super, super important. But then providing easy to understand, clear, timely communications to anyone that's affected about how the benefits from their pensions are going to be affected by the transfer. And that goes right through to any changes, continuations, or enhancements. It's really important that you're being honest and transparent with those employees about the changes or harmonisation, and that you include the timelines for the changes and the actual potential impact on them individually as well. Provide regular updates, opportunities for feedback the whole way through the process, and offer educational resources as well, training sessions, personalised support to help them understand what's happening with the changes to their benefit, and address those concerns, as we've already said, navigate any new processes and systems, and then everyone can go through the transition with as least pain as possible. And the other top tip that I've got is plan. So not just start early, as James said, but also have a really comprehensive plan for integrating those transferred employees into the receiving entity's benefit and pension programs, taking into account differences in things like eligibility for benefit, coverage, and contribution rate, and also a plan for setting up payroll, because you've got to consider the tax, social, and pension contributions that are going to run through payroll as a result of these changes. All of this can be really challenging. So, a comprehensive plan from beginning to end with timeframes is absolutely vital in my mind.
Yeah, I couldn't agree more. I think one of the most impactful sessions that you and your team run on those comparisons of like what the current benefits are, what the future benefits could be, and then how do we then make sure they're as aligned as they possibly can be. I think that's one of the most, and I see that with clients as well when they run through the sessions. It kind of you can do the wow moment. Oh yeah, no, I understand it now. It just puts their mind at ease. Like, okay, we've got a plan here to get through this. So, there's a really great session that you and your team run.
Thank you.
We have one final question, which Emma, this one's for you. So I put you on the spot. This is actually about one of the comments you made about the feedback sessions with employees to the transfer. The question is, what are the legal requirements here? Is there a timeline or format for that?
This is a legal question, so I'm going to hand it over to James, but I don't think there's any legal requirements for feedback after. James, if you wouldn't mind.
Yeah, that's not my understanding, but I think Amir, our employment expert, is definitely on the moderator chat, so he might be able to answer that if it's in the negative, but not to my knowledge either.
Okay, thank you. So that's covering the legal requirement. In terms of how you would run it on a practical basis, I would say that you'd have to have a decent time frame within the first month, certainly, to make sure that you're getting fresh feedback, because we all know that things happen and people get bogged down with other stuff, particularly if they're taking on a new role. So I'd say within a month, and then the format should be anything that, like the way that you would get feedback normally. So a mixture of open and closed questions with free text and comments as well.
I think Amir is typing as well, so hopefully you can get back to Dean. If we don't, if this message doesn't reach you before the end of, there we go. We'll also follow up over email with that, so we'll make sure you've got the answer in your inbox. Brilliant. Well, look, I think that is all we have for today. So there's nothing else here except to thank you very much, my esteemed panelists. Really appreciate all of your insight and knowledge, and I'm so glad that I get to work with you and you can answer all these questions rather than me. It's greatly appreciated.
We love working with you, George.
Good.